The most dangerous mistake a person can make is assuming they already know who is standing on the other side of the door. I heard the tires before I saw the cars. 3 black sedans rolled slowly down the gravel driveway that had led to my family's farmhouse for nearly 80 years, their polished paint reflecting the bright Texas sun as dust drifted behind them like a slow-moving storm. The old windmill beside the barn turned lazily in the warm breeze, and somewhere beyond the pasture, cattle lifted their heads for a moment before returning to the morning grass. Everything about the land felt exactly the way it always had. The scent of fresh-cut hay lingered in the air. A mockingbird perched on the weathered fence post outside my porch. The old grandfather clock inside the house marked another quiet minute with its steady ticking. Then the car doors opened. 3 men stepped out wearing tailored navy suits, polished shoes that immediately collected a thin layer of pale gravel dust, each carrying thick leather briefcases packed with legal files. They looked more like they were arriving for a corporate merger than walking onto property that had belonged to one family longer than most of the surrounding subdivision had existed. Behind them stood Patricia Collins, the president of the Cedar Valley Homeowners Association. She wore an immaculate white blazer, oversized sunglasses, and the kind of confident smile that only appeared on people who believed they had already won before the conversation even began. She glanced around my property with open disapproval, her eyes moving from the aging oak tree my grandfather planted after returning from the war to the faded red barn where my father taught me how to repair tractor engines before I was old enough to drive. To her, none of it represented history. She saw undeveloped land sitting in the way of expansion. I opened the front screen door and stepped onto the wooden porch carrying nothing more threatening than a ceramic coffee mug, still warm in my hands. The porch creaked softly beneath my boots exactly as it had every morning for years. Patricia did not waste time pretending to be friendly. She motioned toward the lead attorney, who pulled a neatly organized folder from his briefcase before walking several steps closer. His voice remained calm and rehearsed, as though he had delivered the same speech dozens of times before. He informed me that the Homeowners Association had completed a comprehensive legal review concerning the property boundaries, future development plans, and what he described as unresolved ownership questions. According to his interpretation, remaining on the land would expose me to immediate legal action unless I voluntarily surrendered possession within 1 hour. Behind him, the other 2 attorneys quietly arranged additional documents across the hood of one of the sedans, occasionally exchanging confident smiles with Patricia as though everything had already become a formality. I took another slow sip of coffee without interrupting anyone. The warm ceramic cup rested comfortably between my hands, while the grandfather clock inside the house continued its steady rhythm through the open doorway behind me. Tick, tick, tick. Every second sounded louder than the last. My name is Nathan Brooks. Most people around Cedar Valley believe I am simply the quiet man who never sold the family farm. They see an aging farmhouse, weathered fences, and 80 years of family history. What they never notice is the neatly pressed black robe hanging inside the front hallway just beyond that open door, waiting patiently for the exact moment when assumptions finally collide with the truth. Nobody in Cedar Valley remembered a time when the Brooks family did not live on that land. Long before the subdivision entrances, decorative stone walls, and perfectly trimmed lawns appeared across the county. My great-grandfather built the farmhouse with lumber. He cut himself from the surrounding oak trees. Family photographs lined the hallway inside, each one quietly recording another generation standing on the same front porch where I now faced 3 attorneys. There was my grandfather in worn denim overalls beside his first tractor. My father holding me as a little boy while we planted a young pecan tree that now stretched high above the roofline. Every picture carried the same background because the land had never changed hands. 80 years of birthdays, harvests, weddings, storms, and quiet Sunday afternoons had unfolded beneath those same trees. Most people assumed I stayed because I was sentimental. The truth was more practical than that. Some things deserve protecting simply because they have already survived so much. Every morning followed nearly the same routine. Before sunrise, I walked the eastern fence line while dew still covered the grass. The smell of damp earth mixed with cedar drifted through the cool morning air as songbirds settled into the old oak branches. After feeding the horses and checking the equipment barn, I returned to the porch with a fresh cup of coffee and spent a few quiet minutes listening to the grandfather clock inside the house. Those peaceful mornings kept me grounded before I drove into town for work. The neighbors believed I managed family investments or handled estate paperwork because I always left wearing pressed dress clothes instead of ranch clothing. They never asked many questions, and I never volunteered many answers. Privacy had become a habit long before it became a necessity. Inside my study, shelves held far more than family photographs. Leather-bound legal volumes filled one entire wall beside carefully organized county property records, historical surveys, deed transfers, and handwritten notes collected over decades. My father always believed that every acre had a story and every story deserved proof. He taught me that memories could fade, but recorded facts had a remarkable way of surviving every disagreement. That lesson stayed with me through law school, through years of public service, and through every difficult decision I had ever been required to make. Even now, every important document connected to our property rested inside a fireproof cabinet only a few feet from the front door. I knew exactly where every deed, survey, easement, and tax record could be found without searching for a single page. The black judicial robe hanging quietly in the hallway never felt like a symbol of authority inside this house. To me, it represented responsibility. Once I placed it over my shoulders each morning, my personal opinions no longer mattered. Only the law did. That was why I guarded the separation between my professional life and my private one so carefully. Very few people in Cedar Valley connected the quiet man living on the old farm with the judge who entered the county courthouse before 8 o'clock every weekday morning. I preferred it that way because respect earned through assumptions rarely lasted, while respect earned through character almost always did. Standing on my porch that morning with coffee still warm in my hands, I watched the attorneys confidently organizing their files beneath the bright Texas sun, and I realized they had spent weeks researching my land without ever taking the time to learn who actually lived on it. Patricia Collins had never hidden what she wanted. From the day she became president of the Cedar Valley Homeowners Association, she spoke about expansion the way other people talked about the weather. Every monthly meeting ended with another presentation filled with colorful development maps, projected property values, and artist renderings of future neighborhoods stretching farther across the countryside. My family's land always sat in the middle of those drawings like an empty space waiting to be erased. The subdivision had grown steadily over the years, surrounding my property on 3 sides with winding streets, decorative streetlights, and rows of nearly identical homes. Patricia often described my 80 acres as the missing piece that would finally connect the eastern and western sections of the community into one seamless development. To her, history occupied valuable real estate. To me, history was the reason the land mattered in the first place. Our first conversation about selling had taken place almost 3 years earlier during a neighborhood appreciation event. She approached me carrying a polished presentation folder and offered what she described as an extraordinary opportunity. The association wanted to purchase the property for a generous price, preserve a few historic elements, and transform the remaining acreage into a signature residential district. I thanked her for the offer and politely declined. She smiled without showing disappointment, closed the folder, and simply said that circumstances often changed with time. Looking back, I realized that was not optimism. It was a promise. Over the following months, letters began arriving with surprising consistency. Some questioned fence locations. Others suggested possible access concerns, drainage issues, or outdated surveys that supposedly required clarification. Every notice arrived neatly typed on official letterhead and always ended with an invitation to cooperate before unnecessary legal complications developed. I answered each one with complete documentation, certified surveys, recorded deeds, county tax records, historical boundary maps. Every response remained professional, factual, and remarkably brief. Facts rarely need long explanations when they are supported by evidence. Patricia's letters gradually became less courteous. Friendly requests evolved into formal demands. Suggestions transformed into legal opinions prepared by outside counsel. At one point, the association even mailed a proposed settlement agreement offering financial incentives if I voluntarily transferred ownership before what they described as inevitable litigation. I filed every document in chronological order inside the same fireproof cabinet where my father had stored decades of property records. He taught me that organized paperwork often prevented arguments before they ever reached a courtroom. One cool autumn afternoon, I happened to pass the Cedar Valley Clubhouse while driving home. Through the large front windows, I noticed Patricia standing beside a projection screen addressing a room full of homeowners. Enlarged maps of my family's property filled the display behind her. She pointed confidently toward the image while several people nodded around the conference table. Although I could not hear a single word through the closed windows, I recognized the expression on her face. It was the same look I had seen countless times from attorneys who believed preparation guaranteed victory. What Patricia never understood was that confidence built on assumptions tends to collapse the moment it encounters verified facts. Standing on my front porch that warm Texas morning, while 3 attorneys confidently arranged their legal files across the hood of a black sedan, I realized the meeting inside that clubhouse had finally reached the conclusion she had been planning for years. She believed the law had arrived at my front gate. She had no idea it had been living inside the farmhouse all along. The lead attorney checked his watch before sliding the first document across the hood of the sedan, as though we were already sitting inside a conference room instead of standing on gravel beneath an old oak tree. A warm breeze carried the smell of freshly cut hay across the porch, while loose pages fluttered slightly in the sunlight. He placed one carefully manicured finger on the signature line and explained that cooperation would make everything easier for everyone involved. According to him, the Homeowners Association had retained legal counsel after identifying multiple ownership discrepancies, outdated boundary descriptions, and conflicting development rights that supposedly affected my property. His words were polished, deliberate, and clearly rehearsed. The second attorney unfolded a large color survey map across the car, smoothing the corners with both hands before pointing towards several highlighted sections outlined in bright red marker. He spoke confidently about revised access corridors, planned road extensions, utility easements, and future residential phases that would benefit the entire community. The third attorney remained unusually quiet, organizing additional binders and occasionally handing supporting documents to his colleagues without saying much at all. Patricia watched the presentation with folded arms and quiet satisfaction, occasionally nodding as each new explanation reinforced the picture she wanted everyone to believe. I listened without interrupting a single sentence. Years spent inside courtrooms had taught me that people often reveal more when they believe nobody intends to challenge them. Every few moments I took another slow sip of coffee, while the grandfather clock inside the farmhouse continued marking each passing minute behind me. Tick, tick, tick. The familiar sound blended with birds singing from the pecan trees and the distant rumble of a tractor somewhere beyond the neighboring pasture. The lead attorney eventually finished his presentation and looked directly at me. He asked whether I understood the seriousness of the legal consequences if I refused to vacate the property voluntarily. I answered honestly. I told him I understood legal consequences very well. He smiled, apparently interpreting my response as the beginning of surrender. Patricia stepped forward for the first time since arriving and removed her sunglasses with deliberate confidence. She looked across the farmhouse, the red barn, the weathered fence posts, and finally the old oak tree that had shaded 4 generations of my family. She said the neighborhood respected local history and planned to preserve the spirit of the property after redevelopment. I glanced toward the oak tree where my grandfather had carved his initials nearly 60 years earlier, still visible beneath the thick bark if you knew exactly where to look. Some things survive because people protect them. Others survive because nobody has managed to erase them yet. The attorneys continued discussing deadlines, settlement opportunities, and litigation strategies, while occasionally referencing court procedures with absolute certainty. Each citation sounded familiar, yet several details did not quite fit together the way they should have. One attorney misquoted a property statute. Another confused a recorded easement with a fee simple transfer. The survey map contained a boundary notation that immediately caught my attention because I remembered signing the corrected county survey myself years earlier. I never corrected them. Instead, I quietly memorized every statement, every document number, and every confident conclusion. Sometimes the fastest way to discover how weak a legal argument really is to let it finish speaking before asking a single question. The conversation continued for nearly 20 minutes, and during that entire time I asked only 3 questions. None of them were difficult. I simply requested the county recording references supporting their ownership claim, the filing date for the revised survey they kept mentioning, and the legal authority allowing a homeowners association to compel the transfer of privately owned family property without a court order. The lead attorney answered quickly at first, flipping confidently through his binder until his pace slowed ever so slightly. The second attorney leaned over the survey map again, tracing property lines with an expensive silver pen while searching for a notation that never seemed to appear. The third attorney quietly opened another folder, turning pages faster each time the silence grew longer. Patricia noticed the change before anyone else. Her confident smile became tighter as she looked from one attorney to another, waiting for the smooth presentation to recover its rhythm. The only steady sound was the grandfather clock inside my house. Tick, tick, tick. Each swing of the pendulum seemed louder than the voices gathered in my driveway. A gentle breeze carried the scent of cedar from the old barn, while dry leaves scraped softly across the porch floor beneath my boots. I watched the attorneys carefully because experience had taught me that uncertainty almost always appears in the eyes before it reaches the words. Finally, the lead attorney cleared his throat and explained that certain supporting records would be introduced during formal litigation. I nodded politely. That answer told me far more than any document could have. If the evidence truly existed, there would have been no reason to avoid presenting it now. The second attorney attempted to redirect the discussion by emphasizing future development benefits for the surrounding community. New parks, improved roads, higher property values, better neighborhood amenities. Every sentence sounded persuasive until measured against one simple fact. None of those promises changed who legally owned the land beneath our feet. Patricia stepped closer to the porch and spoke with the confidence she had practiced for years at homeowners association meetings. She reminded me that refusing reasonable cooperation could become very expensive. I smiled politely and thanked her for the concern. Money had never been the reason my family stayed. Responsibility was. Behind me, the hallway remained quiet except for the steady ticking of the old clock and the faint outline of a black garment hanging neatly beside the coat rack, still hidden from everyone standing outside. My eyes drifted toward it for only a brief moment before returning to the attorneys. None of them noticed. They remained focused on convincing me that time was working against me. Ironically, time was the one thing quietly working in my favor. My watch showed only a few minutes before 8 o'clock. Every weekday morning for years, that hour had marked the beginning of a completely different responsibility. At exactly that moment, my cell phone, resting on the small wooden table beside the front door, began to ring inside the house. The familiar ringtone echoed gently through the hallway. I recognized it immediately without needing to see the screen. It was not an unexpected interruption. It arrived every workday at nearly the same time. The lead attorney paused speaking and glanced toward the sound. Patricia folded her arms, clearly assuming I intended to delay the conversation. I apologized for just a moment, placed my coffee mug carefully on the porch railing, and told them I needed to answer an important call before we continued. Without waiting for permission, I turned toward the open front door and stepped calmly into the farmhouse while 3 attorneys and one very confident homeowners association president remained outside, absolutely certain they still controlled everything that was about to happen. The familiar ringtone echoed through the quiet hallway as I closed the screen door behind me, leaving the voices outside to fade into a distant murmur. Inside the farmhouse, everything felt exactly as it always had. The polished oak floor reflected soft morning light pouring through the front windows. The grandfather clock continued its steady rhythm without the slightest concern for the arguments waiting beyond the porch. Family photographs lined the wall beside me, silent reminders that every generation before mine had protected this place in its own way. I answered the phone before the second ring finished. The clerk from the county courthouse greeted me with the same calm professionalism I heard every weekday morning. She informed me that the first docket had been finalized. Several attorneys had already arrived, and the courtroom would be ready precisely on schedule. I thanked her, confirmed my arrival time, and ended the call. For a brief moment, the house became completely silent except for the ticking clock and the distant song of birds outside the kitchen window. I turned toward the hallway closet where a single black garment hung neatly pressed beneath a protective cover. Every morning I treated it with the same respect, not because it represented authority, but because it represented restraint. I carefully removed the garment, straightened the collar, and slipped it over my shoulders with practiced familiarity. The weight never changed, but every time I wore it, I felt the quiet reminder that personal emotions must always remain behind. The law demanded discipline before it demanded judgment. I adjusted the sleeves, fastened the front, and glanced briefly into the hallway mirror. The reflection looking back at me was not different from the man who had walked the eastern fence line before sunrise. It simply carried a different responsibility. Outside, I could still hear muffled conversation. One attorney laughed softly, apparently confident the discussion had already ended in their favor. Patricia's voice floated through the open window as she assured someone that persistence always produced results. None of them sounded impatient. They believed they were waiting for an ordinary landowner gathering old paperwork before surrendering to inevitable legal pressure. I reached into the fireproof cabinet beside my study and removed a slim leather portfolio containing certified copies of the original deed, every recorded survey, every county boundary correction, and every document my family had preserved across 8 decades. The folder closed with a quiet snap. I carried it beneath one arm, rested my hand briefly on the polished banister my grandfather had carved by hand, and walked toward the front entrance. As I reached for the doorknob, the grandfather clock struck 8 with 8 slow, measured chimes that rolled through the house one after another. The sound lingered in the hallway long after the final note faded. I opened the front door. Morning sunlight spilled across the porch, illuminating the black judicial robe as clearly as the old farmhouse behind me. The conversation outside stopped immediately. The lead attorney lowered the document he had been reading. The second attorney stared silently at the robe before looking back toward my face as though trying to reconcile 2 completely different people standing in the same place. Even the third attorney slowly closed his binder without saying a word. Patricia remained perfectly still beside the sedan, the confidence that had carried her through the morning disappearing behind an expression of genuine disbelief. Nobody spoke. They no longer saw the quiet owner of an old family farm. They had finally recognized the man they had unknowingly been preparing legal arguments against all morning. The silence lasted only a few seconds, but it felt longer than the entire conversation that had come before it. The morning breeze continued moving through the oak branches, carrying the scent of cedar and freshly turned soil across the porch, while no one outside seemed willing to speak first. The lead attorney finally lowered his eyes from the black robe to the leather portfolio beneath my arm. His expression shifted from confidence to careful calculation, the way experienced lawyers look when they suddenly realize an ordinary case may not be ordinary at all. I broke the silence before assumptions could grow into something even more uncomfortable. I calmly explained that I would not discuss the merits of any dispute involving my own property while serving in my judicial capacity, because both the law and judicial ethics required complete impartiality. Personal matters belonged in the proper legal forum, not on the front porch of my family home. The words were simple, but they immediately changed the direction of the entire morning. The attorneys glanced at one another before the second attorney quietly cleared his throat and admitted they had not been aware of my position. I nodded politely. That was obvious. Had they taken the time to understand the person before researching the property, they would have discovered it long before driving onto my land. Patricia attempted to recover the conversation by insisting the Homeowners Association was merely exercising its legal rights. I agreed that every organization had the right to seek legal remedies through proper procedures. Then I gently reminded everyone present that those same procedures demanded accurate records, truthful representations, and carefully verified facts before any claim reached a courtroom. I opened the leather portfolio just enough to remove certified copies of the original deed, the recorded boundary surveys, and the county corrections that had been filed years earlier. I handed them to the lead attorney without another word. He studied the documents carefully, comparing recording numbers with the references inside his own binder. The color slowly faded from his confident expression. The second attorney immediately began turning pages through the survey map they had presented only minutes earlier. This time he stopped several times, reading footnotes that apparently had not received much attention before. The third attorney quietly removed his glasses, reviewed one document after another, and finally closed his binder with slow, deliberate care. Nobody argued. Nobody raised a voice. The paperwork was doing all the speaking. Patricia looked from one attorney to the next, clearly waiting for someone to reassure her that everything remained under control. Instead, the lead attorney respectfully handed my certified documents back to me and explained that additional verification would be necessary before any further action could responsibly continue. His tone sounded very different now. The certainty had disappeared, replaced by professional caution. I appreciated that change because caution usually meant the truth was finally receiving the attention it deserved. Before leaving for the courthouse, I offered one final observation. I told them that legal disputes are rarely decided by who speaks the loudest or arrives with the largest stack of papers. They are decided by whether those papers survive careful examination. Then I stepped off the porch, locked the front door behind me, and walked toward my truck while the grandfather clock continued marking another ordinary morning inside the farmhouse. Behind me, 3 attorneys remained standing beside their sedans, quietly reviewing documents they had believed were beyond question only an hour earlier. The drive to the courthouse felt no different from hundreds of mornings before it, yet I knew the conversations taking place behind me were unlike anything Patricia had expected when she arrived at my farmhouse. The familiar 2-lane highway cut through rolling pastures and fields of hay shimmering beneath the Texas sun, while my thoughts stayed focused on the same principle that had guided every decision throughout my career. The law was never meant to reward assumptions. It existed to examine evidence. By the time I reached the courthouse parking lot, the routine rhythm of the workday had already begun. Attorneys crossed the front steps carrying briefcases. Clerks moved between offices balancing stacks of files. The marble hallway echoed softly beneath polished shoes as the first hearings prepared to begin. I greeted the courthouse staff the same way I always did and walked toward my chambers without mentioning the unusual morning that had unfolded at home. Personal matters remained outside those walls. That separation protected both the office and the public trust placed in it. During a short break between hearings, I requested copies of several publicly available county records through the proper administrative channels. Not because I intended to involve myself in any future dispute concerning my own property, but because I wanted to confirm whether the documents presented at my farmhouse reflected the official filings maintained by the county. The answer arrived before lunchtime. Every recorded deed, boundary correction, tax assessment, and certified survey matched the copies preserved inside my family's fireproof cabinet. More importantly, no document supported the ownership theory presented by the Homeowners Association that morning. Later that afternoon, I learned through public filings that the attorneys representing the association had voluntarily suspended further action while conducting additional review of the property records. That decision did not surprise me. Responsible lawyers understand that discovering conflicting evidence is not a defeat. Ignoring it would have been. Within a few days, another development quietly unfolded. The county recorder's office received formal requests for certified historical documents covering nearly 8 decades of ownership history. Surveyors revisited boundary markers that had remained undisturbed for years. Title specialists reviewed archived plats dating back generations. None of these steps attracted dramatic headlines, yet each represented the legal system functioning exactly as it should. Facts were being verified before conclusions were drawn. Several homeowners who had previously believed the association's version of events began asking respectful questions instead of repeating confident assumptions. They realized there was an important difference between hearing a persuasive presentation and examining verified public records. Patricia herself became noticeably quieter during subsequent association meetings, according to neighbors who attended. The certainty that had once driven every discussion appeared to give way to careful consultation before new decisions were announced. That change alone suggested something valuable had been learned. My family's land remained exactly where it had always been, protected not by dramatic speeches or personal influence, but by documents faithfully preserved across generations and by legal procedures designed to uncover the truth, rather than simply accept the loudest argument. As the courthouse clock struck the end of another ordinary workday, I removed the black robe, hung it carefully inside my chambers, and reflected on the strange symmetry of that morning. They had arrived believing authority belonged to whoever carried the largest stack of legal papers. They left beginning to understand that genuine authority begins with respecting the truth long before anyone ever steps inside a courtroom. Several months passed, and life settled back into the quiet rhythm my family had always known. The old farmhouse still greeted the sunrise with the same soft creak in the porch boards. The grandfather clock still marked every hour with patient precision. The oak tree my grandfather planted continued casting its wide shadow across the front yard, and every morning I followed the familiar path along the fence line before leaving for work. Some things never needed to change because they had already proven their value through generations of faithful service. The legal questions surrounding the property gradually disappeared as thorough record reviews confirmed what my family had known for 8 decades. Public filings reflected the same boundaries recorded years earlier. Historical surveys matched the original deed. County archives confirmed every transfer, every tax payment, and every correction that had quietly preserved the chain of ownership across 4 generations. Once the facts had been fully examined, there was very little left to argue about. The Homeowners Association eventually shifted its attention toward projects that actually fell within its authority. According to neighbors, board meetings became noticeably different. Proposals involving private property were reviewed more carefully, public records were consulted before assumptions became policies, and outside legal opinions were verified against official county documents instead of accepted without question. It was not a dramatic transformation, but it was a meaningful one. Sometimes the most lasting improvements begin with a single lesson learned the difficult way. One cool autumn afternoon, I noticed a familiar white sport utility vehicle slowing as it passed the farmhouse. Patricia remained behind the wheel for only a few seconds before continuing down the county road without stopping. There was no confrontation, no speech, and no attempt to revisit the past. Just a quiet acknowledgement that the land remained exactly where it had always been, together with the family that had cared for it since long before the subdivision existed. I found that moment strangely peaceful because it reminded me that not every ending requires celebration. Some simply require acceptance. Inside the house, I opened the fireproof cabinet and returned every document to its proper place. The original deed rested beside carefully preserved surveys, tax records, handwritten notes from my father, and photographs of generations who had stood on the same porch looking across the same fields. I closed the cabinet gently, knowing those papers would likely protect another generation long after I was gone. Before leaving for the courthouse the following morning, I paused beside the hallway where the black judicial robe hung neatly pressed beside my everyday jacket. One represented my responsibility to the public. The other represented my responsibility to my family. I had never confused the two, and that distinction had made all the difference. Looking back, I realized the 3 attorneys had not truly been my opponents. Assumptions had been. They believed authority belonged to titles, expensive briefcases, and confident presentations. My father taught me something far simpler. Authority begins with honesty. Respect begins with preparation. Justice begins with facts. The land never needed someone to raise a voice on its behalf. It only needed someone willing to preserve the truth until the moment the truth was finally asked to speak for itself. 80 years after my great-grandfather first walked those fields, the answer remained exactly the same. The house still stood. The porch still faced the sunrise. The family still belonged there. And the law, when allowed to do its work with patience and integrity, quietly reached the same conclusion.